Hello, heroes. Welcome. My name is Petra Deeter. Today, we're going to have a conversation about parental alienation in court. And with us, we had the honor to have Judge Peter Sakai, who is running for Bexar County Commissioner's Court, but in Judge in Texas. And but Judge Sakai has been really started the career in service since the 80s and has a lot of experience at children court, family courts, and he has a lot of different programs in the past that really have focused on empowering parents and putting families together. So we are very grateful for him to be here. And I'd like to say though is that I have had a conversation, a private conversation with Judge Sakai before, and actually because of him, that we have been able to achieve a lot of things from his help. So I'm very grateful for him to be here. Thank you so much, Judge Sakai.
Thank you.
I wanted parents, I know people are watching, so if you could please let me know if you could hear me okay. I wanted to make sure that we have the audio working, that you can hear it, and also because always we want to make sure that we don't have some kind of technical problem. I don't see the comments yet because somehow my system is always kind of take time to load. So before we go into anything too serious, let me just check and let me know where you guys calling in from as well. Let's make sure that we are live. I don't see the live stream. Okay, I see. Eva said hi, Rael, Mike. Okay, thank you. So I think we are working. Antonina. Okay, great. Rachel. Okay, great. Thank you so much, you guys. Really appreciate that. Hi, Darlene. Thank you. Okay, so so Jessica, you've seen a lot of cases where parents going in and trying to get custody of the children, and some of the cases are getting pretty heated. Have you ever seen a case that is dealing with parental alienation?
Yeah, the answer is yes. Obviously, parental alienation happens in our family law courts. I was a district court judge, which is the trial courts that hear family law cases here in Bexar County, which is San Antonio, Texas. And so I've heard a lot of cases. I've heard especially child abuse and neglect cases. So I've been involved with children who've been traumatized, and that is one of the essence of parental alienation is the traumatization to the children of a divorce custody case.
Right. So how would you rule when you see a case that you can see this parental alienation?
Well, it's difficult. These are difficult cases because one, the judge needs to assess the evidence and determine whether there is parental alienation, especially in high conflicts or complex cases involving child custody. And so the judge has to have the ability to kind of separate it all, make that determination of whether there is parental alienation, which is the manipulation of the child against the other parent. And so once a judge determines that there is parental alienation involved in a particular case, then what I did, and I'm speaking for myself, and every judge probably handles it differently, and I'm sure your audience is probably, if they've been in the courts, some have been pleased and probably have some have not been pleased with the outcomes. But as a judge, I tried to equalize the power, the leverage that the parents had, so that the parent who's committing parental alienation would typically not get primary custody. The parent who is committing parental alienation would probably get less time, visitation access. Oftentimes we would order psychological evaluations or get therapists involved, especially trying to get therapists that would, excuse me, my dogs are barking here. That's
He
a
has an
problem with
opinion.
love. And so just please excuse the barking dogs. But getting back on task, it's basically the judge trying to equalize the power, the leverage that parents have in these high cases involving parental alienation.
Thank you so much. Actually, you point out some really important points. So definitely, yeah, when it comes to parental alienation, is a manipulation of the child. And I'm so grateful that you actually recognize that really the trauma is on the children. The children are the one that truly suffer. And there's that power imbalance between the two parents, the one that has the power to manipulate the child, and the other ones actually using the child as a weapon against the other parent. So thank you. So the thing is, when you go into situation, like when you go into a case that have parental alienation, usually the parent that is the target of parental alienation are usually in so much pain because they're suffering from this, losing their children, seeing their children turn into this sort of like a monster that's going against them, and it's very hurtful, and they tend to get very traumatized, and so it's easy for them to kind of look like they are unfit parents, like maybe, and sometimes not to that, even sometimes there's a lot of issues with false allegation. I think I would love to talk more about that in a bit, but how would you advise parents to go in to present their case so that the judge can see them as fit parents that are capable parents that they can see, that the judges can see parental alienation as a problem there?
Well, first and foremost, most parents, if they have the ability, and some do, would hire an attorney. So first, you want an attorney who understands parental alienation and the complexities of that, and is able to assist their clients in presenting their case, and then allowing the attorney to do their jobs. And hopefully you have competent counsel. Now, not all attorneys have that competency. Not all attorneys have that training. And so you have to be very careful with the quality of legal representation. And unfortunately, that is an issue of our justice system. People who can afford the best attorneys sometimes get the best outcomes. And I don't know if that's necessarily a fair, just system, but that's the way it is. The other thing for those parents who perhaps represent themselves, we call pro se, self-represented litigants. I guess my feedback to those parents who present their cases is to focus on the positive aspect of themselves, as opposed to trying to focus on the negative aspects of the opposing parent. Because that's, in essence, sometimes that's what's so very, very tough. People want to tell me what's the worst of their other spouse, of the other parent. And sometimes that can be misinterpreted as alienation. And that's where the training and the experience of a judge is really crucial, because sometimes it can be misinterpreted as alienation, and sometimes it could be missed because it could just be, well, it's just an angry parent, when in fact it is a parent who is committing alienation and is very manipulative and very deceptive. And so that's why parental alienation cases are very, very tough for everyone involved, and especially, as you have pointed out, on the children and the traumatization of children.
Right. And that's a problem that you mentioned about, sorry, I feel like my, something wrong with my stream. So just give me 1 second. I'm sorry. It just keep doing, this is like the hundreds. I'm not sure how many hundreds stream every time. I don't know why every time it creates some kind of problem. It's always send some kind of error messages. I'm gonna just ignore that. I'm gonna assume that it's still working. It looks like it's still working, but anyway. So yeah, no, you're right. So the best thing is if you could get an attorney that really truly understand parental alienation and how to present the case. But that's also another challenge, which is, like you said, a lot of attorneys are not knowledgeable about this, and this is a problem that we face as the whole community, is that there's a lack of awareness and education and training at all levels. And you're talking about, from the school teachers that are dealing with the children to, therapists, mental health professionals, to the family law practitioners and judges, and that's a huge problem. And actually, this was your advice for us, and this is why we start to reach out to a lot more judges and association, including NCJ, FCJ, and AFCC and things like that. So we are really grateful to you about that. So one of the things that I've noticed is that, and I do see a question, I think from Mike or someone in the room. Yeah, actually, I think Mike said, have you seen attorney escalate the litigation? And because I felt like the system is incorrectly incentivize people, because the longer the case drag out, the attorney get paid more, more billable hours. So the system is actually really not to the benefit of the children Do you have any thoughts on that?
Yes, I have seen that. And one thing that I did as a judge is called docket control. And what docket control means is the judge takes responsibility for the progress or the pathway. It's called basically the process, the calendar, so to speak, of a case. And the more high conflict and highly adversarial the process, the more I push the parties to basically set a date and set firm dates so that people knew that there were deadlines and that there was a date that hopefully a resolution. Now, some cases cannot be resolved in a very quick time period, and they need what's called discovery, and they need expert evaluations, and they need bring in experts to determine whether there's parental alienation. So cases take time, but you are correct in an assessment of our justice system that unfortunately there is an incentive for cases to be dragged out. There are incentives for cases to become more adversarial in order for attorneys to create more billing. So I think that's the reason why the client needs to be empowered with knowledge and training as what you're providing, so that when they talk to attorneys and interview attorneys, they have a comfort level and a trust that their attorney is going to do the right thing, that their attorney is going to try to get a resolution as quickly as they can, not drag it out, and traumatize, especially the children of the lawsuit. I have seen protracted litigation where I was convinced that the children were permanently harmed because of the adversarial nature. And that is a tragedy in itself, that the justice system that is supposed to speak out and protect the best interests of children doesn't do that. And so as a judge, I just tried to provide a neutral forum, to provide dignity and respect to everybody who comes into the court. And that was more of a personality issue with me. I really wanted the opportunity to speak to the litigants. And in our adversarial justice system, the attorneys tend to control and present whatever evidence they deem to be necessary and important to the judge. But I thought it was always necessary. And really, I made every effort to talk directly to the clients. But unfortunately, sometimes attorneys being attorneys, they didn't want that. And so we have a lot of work to do, Dr. Deeter. And that's the reason why this conversation, this training, and your efforts to connect with the professionals that are involved in training of judges and attorneys, we've got a lot of work to do.
Thank you so much. So you mentioned about you trying to set a date. So I saw Rachel ask a question in the conversation there. She's saying, so is it possible for the parties to request a date, or is that just only the judge? Is it being unreasonable to trying to say, could we please have some sort of kind of deadline on our docket?
Yes, you call it, what the legal term here in Texas is called a docket control order. And so you really, anytime a case first gets filed, it's usually brought into the court. And one of the first things I do when I see that it's possibly high conflict is commit everybody to a docket control order to anticipate how much time they may need to do what's called discovery and to do the things necessary to prepare for trial. And then put a date in advance, because in our jury system, we do have backlogs, especially in the post-COVID world. And so we're dealing with backlog of cases. And so the sooner you put it on the calendar for a trial, whether it's a jury or non-jury, a trial before the court, the sooner you get it on, the sooner it's docketed. And understand those settings always can be reset, usually by agreement. And usually judges are very lenient in allowing cases to move on. But at the same time, lawyers are not really good about that in some situations, and that's because they'll just let the case go on, and it's up to the clients to say, "Hey, this is my case. I'm in charge of it, and I want my trial, and I really want to get on the docket." And they should be given instructions to their attorneys. I need a docket control order. I need to know so that I can prepare. I can take the time off. I can then anticipate the costs that are going to be necessary, so that they don't get sticker shock of the legal fees. And unfortunately, I see time and time again where attorneys withdraw in these cases because there's no more money. And it is a tragedy where I see parents who have really cases that need to be tried, and they have no money or resources or no attorney at the very end. And that's, again, something your clients, your patients need to be very aware of, is that the justice system, they need to take responsibility for their own actions and the choices they make, especially when it comes to the attorneys they choose.
Yeah, this is something that we talk a lot about parents, is that to parents, is that you have to try to do a lot of self-education. You kind of have to be in the driver's seat. You can't expect to just kind of hand your case over to somebody else and just sit there and they will take care of it. Unfortunately, nobody is going to be truly driven as you are to fight for your children. So really, you could have an amazing attorney, you could have not so good attorney, but really definitely do whatever you can to get as much information and knowledge as possible and be in the driver's seat for your case.
And let me follow up, Dr. Deeter, with sometimes the litigants, your clients will say, well, why isn't the judge trying to equalize it? And that's where the role of the judge is, as a neutral arbiter, needs to always remain neutral. And so it can't appear that he's trying to help one side or the other, because one side seems to be getting taken advantage of. And so I'm sensitive to litigants who represent themselves against an attorney who is on the other side. But at the same time, I can't weight it so that the pro se litigant gets all the rulings. I have to make rulings, and unfortunately, people who represent themselves do not know the legal terminology. They don't know the legal objections. They don't know that they can't say certain things. They're like hearsay. And so it is a very tough process in the courtroom. And so again, that then goes to where mediation and arbitration and alternative dispute resolutions are very important in these type of cases, to try to avoid having that trial. It's trauma in itself to go through an extensive trial.
It is, and it really, I mean, you're talking about time, money, stress, anxiety, everything, and then in the meanwhile, the children are suffering and they're growing up. Time's passing by. Like I see Carolyn in the chat room said, my daughter's case has been in the state family court for 13 years, and I mean, I know, and we see many parents with that kind of situation. I saw Rachel said, I completely agree. Bertie said, I wish I'd known this earlier. Melinda said, yes, it is. So that's the thing, is we've seen, and then before you know it, the children are out of the jurisdiction of the court, and the impact is for life, and that's really tragic. So we've seen cases go in and out of courts, because you're dealing with a particular type of personality that may have, a personality disorder or something like that, or at least behaviors that match that kind of personality disorder. So have you seen cases where where a parent may have to deal with false allegation of child abuse or or child neglect? Have you seen those cases?
Yes, they're not often, but there are cases of false allegation, because that's a false allegation can be weaponized in such a devastating way, and I've seen it to where there's truly false allegations. There's no basis whatsoever except for the manipulation of the parent who's committing parental alienation. And then there's those cases where perhaps there is some suspicion, or there could be some credibility to allegations of abuse. And so those get real tough, because once I have colleagues that once they hear child abuse, sexual abuse, those type of allegations, they immediately put red flags on. And so that's the reason why parents need to try to avoid the courtroom, because sometimes judges don't get it right. They just don't. And sometimes they will. Now, I will tell you, in regards to false allegations, I typically, and especially in pre-trial, where those issues come up before trial, and there's issues of allegations of abuse, usually what I do is make a thorough admonishment that, at least here in Texas, there is a law called false claims of child abuse. And Texas law says that a parent can lose their rights or get their rights diminished if false allegations of child abuse can be proven. And so when I tell parents, look, I understand, and we're going to let the experts, therapists, doctors, mental health professionals get involved here and do the assessments. But if these allegations prove to be false, your rights could be restricted. And basically, you could lose primary custody or get visitation denied or get visitation restricted or supervised at all times. And so I make it very clear, once you make these allegations, you better be prepared to prove it. And I've had the situations where the Child Protective Services, the child assessment centers that are involved in these cases come into court and say, Judge, these are not, and I had to tell the parent who's making it, you understand, these are the experts. And they have no bias or predisposition to favor one parent or the other, and they say there's no faults. Now, you can go to your grave believing that there are allegations of abuse, but you understand, as a judge, I have to determine upon a preponderance of the evidence, the greater weight. And unfortunately, if you can't prove, and that's usually what happens, is there's no proof of the allegations of abuse, and there's proof that there are false allegations. So the judge is compelled to find that these are false allegations and must rule accordingly. And usually, if the parent who's committed these false allegations usually will not prevail in the court, and they will end up losing their rights.
Thank you so much. Actually, I wanted to kind of put an alert here. I know that my team is watching. Can you guys just take a note of this? Is so important. I didn't know that actually there's a law specifically deal with false allegation of child abuse. So thank you so much. I know that there's perjury in a lot of states, in all jurisdictions, there's a law for perjury. Unfortunately, what we have seen is that it's never enforced. And it seems that it's a criminal matter, and then things are going on within the family court. It's a civil side. So stuff that going on it just seems to get washed over. And like you said, as soon as there's this allegation of child abuse, suddenly the case is being seen differently. And a lot of the time, sometimes you get a chance to prove yourself, and sometimes you can't even prove it. But if you have and sometimes you don't even get a chance to prove yourself, but yet the judge still takes that allegation in the back of their mind in their determination. And so you don't get the chance to clear your name, but yet it impacts your case. And actually people call this the silver bullet, the false allegation of child abuse. And so there's a lot of question about, how do you prove that you are innocent? How do you prove that an allegation is false?
Well, basically, again, you focus in on the positive aspects. And that's the reason why I know that that's counterintuitive. Like, no, I need to prove the negativity or the allegations against the other parent. And I try to, at least in my mind, I hope the parents who are involved in today's event understand that by showing what you do as a parent. This is what I take care of my kid. I make sure that the kid gets to the appointments. I'm in charge of the discipline. I'm in charge of the religious training. I'm in charge, and show how great of a parent you are. And these are the things we do when we're on our time in recreation. And this is how we involve them. This is how I help them study. And so the more you can convince how positive you are as a parent, the more you can dispel that, hold on, these allegations they're not consistent. They don't work. It have to be a Dr. Jekyll, Mr. Hyde situation. And so it's one of those situations where I try to help parents, or, in these type of forums, to say, show the best of you, show what you and your child is all about. And I believe that's the best way to counteract false allegations and to disprove, because you can't prove a negative. You just can't. I mean, well, you can hire the experts. You can go again, and that just puts the cost of litigation through the roof when you have to hire psychologists, psychiatrists who bill at just expensive hourly rates than attorneys.
Right. So this is also another situation that we've seen a lot, is that, you got a false allegation. Let's say at one point it's like, oh, there's this particular allegation of, let's say, sexual abuse. And then the parent would fight and be able to clear their name, have the children for maybe before they even get a chance to resume their time with their children. There's another false allegation. Now they're back in court again, take 2 years or whatever for them to finally get a hearing and clear their name again. It's a different allegation, right? So before they get to resume their time, another false allegation come in. And so you just end up like fighting this series of false allegation, and they're all different allegations. Have you seen those? And what advice do you have for those parents that have to deal with that?
We've already touched on it. That's the reason why when that case first comes in and you know it could possibly be a parental alienation or high conflict, get a docket control order. Set the case on the docket. Set the case so that within a year's time, there's at least a trial date for finality. And then that way, once these allegations keep popping up, there's going to be a strong argument. Judge, you need to make a decision. We just got to put an end to this madness of allegations after allegations. I get an allegations, I get cleared. Another allegations, I get cleared. Judge, this is parental alienation. Please stop it. And that's the reason why my suggestion of a doc control order and having clients take control of their case and having the attorneys or the court, if they're representing themselves, judge, please set this thing for trial. I know it's scary to say set it for trial, but the more you put accountability into the system, the better I believe the outcomes will be. Otherwise, you're allowing the system to take control. And Dr. Deeter, you've kind of illustrated how the system can be when it takes control of the case and the litigants feel that they don't. And I understand they have a presumption that the system is going to try to do what's best for their children, but it's an adversarial system. It's going to do what's best for the litigants as they present themselves.
Right. Yeah, I saw in the chat room, I think Stan said that he or she record all the conversation. Definitely keep records of whatever's going on. Definitely. We do.
Let me interrupt on that one. You got to be real careful. Here in Texas, the recording can only be done by the court reporter, if there is a court reporter in the courtroom, and you need to be, because the law does prohibit recordings, especially without permission. So be very careful in courtrooms and understand the rules of recording.
I think he or she's talking about at home.
Okay.
Like the conversation with the children or something. I'm going to assume that. I'm not sure. Because I think she's trying to say that I can then prove that I'm not abusing my child. Yeah. Okay. So, and then, he or she respond that they are in a one-party recording state. So yeah, that's also another point that's also important is, definitely watch out for the law, because in some state it's two-party consent. That means that you cannot record without the other party also agree to that recording. Otherwise it's also illegal. So definitely in some state it's a one-party consent. So as long as you are a part of the conversation and you consent to that recording, then that's okay. So definitely watch for that. Yeah, Stan was saying, I'm talking about recording at home. Okay, definitely. Thank you so much. And then have you seen parental alienation being falsely used as well as a term in order to get away with it? To say, oh, it's the other parent is the one that is, alienating, but in fact, that parent is the one that is, abusive or toxic.
I've seen it. It's probably more rare where the alienator is using a reverse psychology, so to speak. And again, that's the reason why these cases are so complex, and that's why training and awareness and empowerment are so crucial in these type of cases.
Right. Thank you. So Melinda said they wouldn't even hear my recordings. Okay, so this is talking about being able to get evidence into your cases. Yeah, actually, that's a good question. What advice do you have for parents so that they have a better chance of presenting their evidence or information?
Well, unfortunately, that's the reason why you need an attorney, and an attorney who's trained and has a competency and hopefully has an expertise with these particular cases, because obviously a lot of times the statement of the children are necessary, and not all statements of children can come in. There are what's called exceptions to hearsay, which would allow statements by children, but you have to understand the rules. And that's the reason why self-represented pro se litigants, are at a disadvantage, because obviously unless you went to law school or you do a little bit of research, it's very difficult. Now, some judges, and I'm one that tries to be more lenient in the application of technical rules. I've had litigants where they're pro se litigants on both sides. There are no attorneys involved. And so typically in that situation, I just say, look, why don't I just let you speak without interruption, and you just present your case, and I'll give you a time limit, and then I'm going to give the other side the same, and then I will ask questions. And usually in those type of scenarios, I'm able to basically do a pretty good assessment of the case, but at the same time, that's up to the judge. And some judges may be more traditional, more conservative, and they're like, nope, you must answer in a question answer format. You must make legal objections. I will not give you any legal advice or give you any type of admonishments that might help you proceed forward. And so when you're in those type of courts, then, you do the best you can. The thing that I would recommend to any litigant is that even though it is very frustrating, you can get very angry and don't kind of, in essence, bite the hand that feeds you, which is the judge. Don't start fighting or being disrespectful or being sarcastic in any way toward the judge, because judges can really impose and be their rulings will end up being what will be very dispositive.
It's not helpful. It's not helpful for you, right? I do see in the chat room, Carolyn said that she was actually being accused by the alienator to be the alienator. So just unfortunately, you're dealing with people that are really essentially abusive. So you're going to end up with all sort of accusation against you, all sort of allegations against you. So definitely. So there was a question, I think, from Julie about training for judges, because you brought this up about, some judges will see it, some judges will get it wrong. So it comes back to awareness and education. So with your jurisdiction, her question was, who does the training for judges in Texas?
Well, it's called the Texas Center for the Judiciary, for which I was on that board, and that's the reason why I was very involved. And I advocated with our family law judges that they get these type of training, especially trauma-informed care. And that's the big topic, so to speak, here in Texas, is that judges need to understand what trauma does to people, especially children. So as far as that's concerned, that's kind of internal. If you're an advocate out there or you're involved in whatever interest groups that perhaps are involved in parental alienation, you as a group should be advocating for training. You as a group should try to meet with the local judges in a more informal, not we got a complaint, but hey, judge, can we talk about issues that are important, and hopefully, be assertive, and the worst that you're going to get is the judge says, no, I'm sorry, I don't talk to the public, I don't need to talk to the public, and it is what it is. But you also have a newer generation of judges. The younger generation of judges, I believe, are going to be, I think, more open and receptive and not be so conservative. And what I mean by that is putting on that judicial robe and basically sitting in what we, in our world, is called sitting in the ivory tower, and not having inner contact or connection with the community. I think the younger generation of judges want to be connected. They want to hear what the public has to say. And so the more y'all have dialogue with your judiciary, the more you can say, hey, judge, these are tough issues, and we've done research, and there's the National Council of Juvenile and Family Court Judges. There's American Courts of Conciliatory Courts who have wonderful training. Y'all should basically go to those conferences if you're allowed to. And I think some of those conferences do allow public to participate. And that would be a wonderful time for y'all to go and be a voice for those people who have been affected by this issue of parental alienation. And so it's basically, it's kind of like the issue of politics. You can be silent and complain, or you can step up and voice your voice and vote and make it clear that you're going to vote for officials who understand the issues and understand that there's more to it, and that training is an important part of having the best professionals in our system. Definitely. And then also too, with the mental health, you should be outreaching with mental health professionals who and ask them, especially those that have an expertise with parental alienation, come speak to our group. Come speak. Hey, what? Well, let's have a training locally and meet our local judges. You know,
Right.
everybody's just got to be assertive and aggressive in the most appropriate way, most appropriate and courteous way. Got to
Right.
always remember, be courteous.
Yeah, proactive, yes, but not rude. So
That's right. Not that's the better way to say it. Don't be rude.
yeah, so you have mentioned about mental health professionals. Who else could help? Who else sometime might be involved in a litigation?
Well, every once in a while, and usually they're not involved, but there's in some jurisdictions, child advocates, volunteers, CASA. They're typically in the abuse and neglect world, the child protective world, but that's another group. Basically, you could create a group that would provide support services, guardianship services for children. And so I think the more the community comes together and finds advocates for within their groups and hopefully sits down and bring everybody together. That's one aspect of my leadership as a district court judge. And I didn't profess to have all the answers, and I don't have all the answers, but I knew what the problems were, and parental alienation is a big problem. And I would say, hey, let's bring the experts in and let's sit down and let's basically, it's not so much like it could be like a town hall meeting, but basically let's convene and let's talk it out. And hopefully you have the judges in the room, you have the lawyers in the room, you have the mental health professionals in the room, you have just concerned advocates in the room, you have parents who have been aggrieved or parents who have an interest in this issue, and be all in the room saying, hey, how can we make our justice system better? And what solutions and processes do we need to do? And like I said, Dr. Deeter, one of the things I really pushed upon you in our first meeting, training, training, training. We just need to have more awareness and have the ability to deal with these complex issues.
Yeah, so from the meeting with you, Judge Sakai, we actually went to NCJ, FCJ, and the AFCC, and we found there's in Massachusetts there's a particular specialty court, and you kind of mentioned this earlier about how you wanted to be able to talk to the parents so that you can actually really hear instead of just the legal jargon and also sort of show that the lawyers put up. So this specialty court is sort of for custody cases where the judge actually not, even though it's still a legal proceeding, the judge, they actually sitting at a conference table with the judge instead of the judge behind the setting, and they actually all talk together, and they call it a team. So parents are part of this team, and it's trying to be sort of less adversarial and less intimidating for parents. And so this is something that we actually working right now with a legislator in Texas, and we're trying to implement this in Texas. What is your thought about that specialty court?
Well, that's the model I've been doing for decades now here in Bexar County. I have what's called I helped create what's called a family drug court, which was cases involving abuse and neglect children that were removed from their parents who had severe or serious addiction issues, both either drugs or alcohol. And we put them through intensive programs, much as what you just said. It's bringing all the stakeholders together in a round table. I don't sit on the bench. I come and sit at the council table along with all the stakeholders. And we address the litigant, the parent, in a multidisciplinary way to resolve the issues. First, we've got to get them sober. We've got to get them through treatment. And then we hold them accountable through random drug testing and alcohol testing. And then if they're testing positive, there is a sanction to promote the accountability. And we have seen tremendous success when you put parents on a path of sobriety. You deal with their mental health issues, you deal with their trauma, and you deal with then all the other issues that usually deal with poverty, housing, living in, in the bad neighborhood, so to speak, and being exposed to the criminal element, not having a home. Not having a job, not having a driver's license, social security card because you've got too many traffic tickets. And so you deal with the parents as they come in. That's based on what we call the restorative justice. That is focusing on the positive aspects of people who come into our courts, and then focusing on their positive attributes and enhancing them to teach them accountability and responsibility. And it's basically the formula for what we do for our own kids. We teach them that, and they then become successful, mature, tax-paying adults. And the other court that I created was early childhood court, baby court, where we work with mothers, young mothers, with their babies. Because unfortunately, we have a big issue in San Antonio where moms are using drugs, and their drug-exposed babies are usually removed at birth by Child Protective. The Child Protective has been very aggressive in removing these children. And unfortunately, if these parents don't get engaged with the program, they will lose their rights, because I can tell you, we have a long list of parents who are ready to adopt babies out of the foster care system. And so I wanted to stem that and say, hold it. Let's focus in and deal with these parents. And again, when you deal with it in wraparound services, you wrap it and make sure that their issues are dealt with in a positive way. And then ultimately, this is what I learned, and this is kind of a corollary of what I said earlier. The parents learn to trust the system. They learn to trust the people involved, and that goes a long way. And so, unfortunately, when you're in your family law courts on parental alienation, you don't have these supports. So I applaud the state of Massachusetts in creating a specialty court for these type of cases. And now that you think about it, I'm like, duh, we should be having these type of courts for high custody, high conflict, parental alienation cases to protect the children. Those are our most precious commodity, and we need to do a better job about that. And our system, we still have a lot of work to do. I will candidly admit that we don't always do a good job.
Yeah, so that's what we're trying to implement right now in Texas. We work with some judges and also the legislators, so which started the conversation. The Massachusetts court actually gave us all the forms that they use, that they allow us to use it in Texas. So hopefully we can implement this in Texas soon. So thank you. So I'm glad to get your feedback on that. There was a question earlier, I think it's from Adrian, about judges in your county, but I think I'm going to make it kind of broader. So what happened when, do you have advice for when a parent go in and they can see, like, because they've been in and out of the same court, and they could see that their judge really doesn't get it? What can a parent do when they deal with a judge that's clearly very biased and really don't get this? Is there anything they can do?
There's a mechanism to try to get a judge off, but it is very, very difficult. The presumption is always that the judge is going to be fair and just and not biased. But unfortunately, some judges, and it's not. Let me kind of say something on behalf of my brothers and sisters on the bench. It's not so much that they have a bias or predisposition. Sometimes they don't, I guess, present or convey that impartiality. And so that's a training issue. And so, it's a way a judge addresses litigants, and if they're addressing a litigant in an informal way, but then in a formal way to the other litigant, see that creates a perception of bias. Or, and I can tell you where litigants really go crazy is when the familiarity with the judge and the attorneys. And the judge will joke with one attorney and not joke with the other attorney. And
right.
And I was always mindful that once the litigants came into court, we better put on our best presentation, and let's watch the informality and watch perhaps the remarks or the facial gestures that might reflect. So, I understand that bias and prejudice can play into a judge's ruling, but more times than not, it's usually the fact that the judge's rulings are the litigant is not happy with the litigant, and so then they obviously go to, well, the judge's bias or prejudice. Unfortunately, and I've seen that, once you kind of put that out, so to speak, or make that accusation, and you can't prove your case to recuse, that means get the judge off, you're pretty much your case is not going to go pretty much the way it's just going to get worse.
Right, because
and so you really have to, and that's where, again, parents, and I say this in a very generic way, but I try to say it to where they can help understand. The more you try to control the courtroom, the worse it'll probably get, you know. And I realize that it's your life, it's your child, it's everything to you, but it's kind of it's a lot of it is based on my belief and faith that is very important to me, that you can't control things and you got to let go, and you really do have to let your attorney or yourself. And you know, Dr. Deeter, if I don't mind, if you allow me to kind of touch on a religious type of analogy, but it's the King Solomon story, right? Where, you know, he's got a baby, he's got to figure out there's two women fighting for it, and he says, "Fine, I know what I'll do. I'm going to bring my sword out and I'm going to cut this baby in half." And he does that, and the mom that says, "You know what? You can I don't want, you can have the baby. I don't." That's the parent that he went with, because he knew that that parent, out of love for that child, was willing to give up that child. And so I use that analogy occasionally in the court and say, hey, you know, I realize this is a hotly contested, and everybody, and somebody needs to win or lose, but that zero-sum winner take all does not serve these children well. There's got to be, and so I do everything I can to push to settlement. I do everything I can to push to mediation, arbitrations, alternative disputes, so that, you know, we can then move on. But that's an example of why trying to control the courtroom, control the judge. I can tell you, nobody's going to control that judge, so don't even try. And if you do that, guess what? That does look like alienation, doesn't it, Dr. Dieter?
Right.
If that litigant, that parent's like, well, I got to convince this judge. I'm going to do everything I can to convince this judge. I'll go to the end of the world to convince this judge. Guess what? There you're like, oh, there's some smoke there, and if there's smoke, is there a fire? And is, you know,
right.
It just doesn't get any better.
Right. Yeah, no, thank you so much. I definitely, and this is something that we say a lot, and thank you, Fredericks. He said, thank you for your hard work. Thank you. So we say this a lot, and I want to re-emphasize this for parents, is that in the courtroom, unfortunately, it's like a foreign country where they speak a different language. And so you have to try your best to understand that language so that you can present yourself the best way possible. So when things go wrong, sometimes it may not be because of the judge. It may be because you are not speaking the right language. So definitely get a lot of self-education, get the right advocates around you, whether it's lawyer, therapist, or whatever it is. Definitely really be in the driver's seat in a way that really truly understand what's needed and how you present yourself. So when things go wrong, don't just immediately go and blame somebody. It's sometimes it's because we don't understand that language, and we don't see how we present ourselves as well. So definitely trying to be a little bit more, I guess, positive in how you look at things.
Dr. Dieter, let me take that statement and give you a little more of a concrete example of what I see. And that's the parent, the litigant, who in their best efforts says, you know what, I know what I want, and basically they start acting as if they're their own lawyer, or they get into the mindset of a lawyer, knowing that they don't have the training or the expertise or the language that, and you really have hit it, the language, and they really start trying to be their own lawyer, so to speak. And let me give you an example, and it's in the question and answer format of a parent who's on the witness stand, and he's given a question, and usually and most attorneys ask questions for which they know the answers. It's called cross-examination, right? And so it's usually a yes or no. Now, the attorneys are always trying to phrase it so that, and so what happens is I get parents who say, oh, I know what you're arguing, and it's totally ridiculous what you're trying to say, and blah, blah, blah. And so you're like, look, just answer the question, and then I'll let you explain it. Now, that's something I will do as a judge, and I will cut lawyers off. Hey, if they need to say yes or no, but they need an explanation or a caveat to it, then I'm going to let them. Now, that's my personality, and that's me to allow that question and answer format to try to proceed. Otherwise, then you have these knockout, drag out question and answer formats where attorneys are yelling, screaming at times at the litigant, and then the litigant's screaming and yelling back. And it's just, it's an argument that has no merit and no value because it's just people making noise, so to speak. And so I'm hoping I've made my point where litigants need to try to answer the question as best they can, as brief as they can, and really leave the argumentative, and especially the snarky, sarcastic remarks. You really do not score points when you go down that path of trying to out-lawyer or beat the lawyer at his, and because most times than not, you're not. And you're gonna come across as, oh, again, you're the one that's manipulating, you're the one that's trying to control. And guess what? That's what alienation's about. And so that's where you gotta be real careful. You see the double-edged sword of that. It comes back to haunt you.
Right, because your goal is to show that you are a loving parent, and then while you're acting like you are sarcastic and trying to be abusive or trying to be aggressive, then they only see you for that whatever time in court. They're going to assume that that's how you are to your children outside of the courtroom, and so it's hard for you to try to get a positive outcome for yourself and your child. Yeah,
you hit the nail on the head.
Thank you. So recently, the AFCC and the NCJFCJ, and for parents that are not familiar with these organizations, the AFCC is the Association of Family and Conciliation Courts, and the NCJFCJ is the National Council of Juvenile and Family Court Judges. So these are the organizations that consist of judges and lawyers and therapists, like family law practitioners in the family courts. And they released a joint statement, and in there they mentioned that family law practitioners should receive regular and ongoing training on various factors relating to parent-child contact problems. And in there they listed, denigration, parental alienating behaviors, and healthy parenting. They also mentioned about how, in order to recognize and identify or diagnose, parent-child contact problem, family law practitioners should take time to see if it is to do with, whether it's domestic violence or it's to do with parental alienating behaviors. What do you think, what is the weight of this statement? Do you think this is going to have any implication on making true changes in terms of, the training that the judges and the lawyers are going to get?
I think that's where the system needs to go. The more knowledge, the more power you have. That's a fundamental principle that I live by. So the more training that attorneys get, the more training judges get, the more training the practitioners, the mental health professionals get, the better the outcomes are. And the main thing is that it goes to the basic question of, we need to make decisions in these cases. You can't let these cases linger, Dr. Deeter, and then that horror story of cases going 13 years. Oh my gosh. And this is to kind of bring it back to what I do. I tell the parents when we first start a trial, I said, have y'all really sat down and talked to each other and try to resolve it? And, sometimes they say, yeah, Judge, and we just can't, and you need to make the decision. And sometimes they really, no, we haven't. And so what I do when I find that situation where I try to encourage people to talk and reach some type of resolution, I try to remind them that they're the mentors, they're the examples that their children will live by and grow by. And that what they see as through them as parents is what the way they're going to be as parents. And I try to let them know that the payback with the process that they're going through is, if you can't show your children how to resolve amicably, or at best you can, to resolve your differences, then you're teaching them how they're going to be as parents, and that their rights as grandparents are going to be severely impacted, if not restricted, because their grandchildren are then going to repeat the same mistakes that are being made today. And occasionally that has come through, and it has at least opened the door, opened some eyes, so to speak, of, there is a cost of litigation. There is a cost, and there are the short-term costs, of course, the cost of the attorneys, and there are the long-term costs, and that is the relationship you're going to have with your grandchildren. And so that's something I hope all litigants are aware of is that, again, under the parable of the King Solomon, sometimes you just have to let go.
Yeah, yeah. Yeah, so I mean, definitely, I think that's helpful to a lot of cases. Unfortunately, there are situations where there are people that truly narcissistic sociopath. And I saw in the chat room, Julie mentions this. I saw Kim said, I'm actually afraid of talking to my ex because he turned really mean. We see this, and we also see a situation where you're trying to, parent trying to talk to their ex, and then the ex then twists their words into and then use that against them. So yeah, sometimes it works, sometimes it kind of doesn't, right. Unfortunately. But you have to try, I guess.
And I think that's where that parent in that situation needs to go to a mental health professional so that they're empowered how to talk to these parents who have personality disorders. I agree that a narcissistic, misogynistic parent, I've seen them. And yeah, you need to be very careful in your communications because everything will be flipped around. And so, and the main thing is not to allow that parent, because you're going to have to deal with, especially if you're co-parenting a child, you're going to have to deal with that parent in some way or some fashion. And the more empowered you are, which means talking to a mental health professional as to how do you deal with a parent who has those issues, and how do you keep from falling into trap. And it's usually that, what's that old saying? Don't bite, don't bite the hook. Don't take the hook.
Yeah, don't take the bait.
Don't take the bait. And so, and those are things that parents, I realize that's easier said than done. But I think it is something that parents need to learn in this world of high conflict. Don't take the bait.
Right. I know that we're kind of running out of time now, and there's more than 160 comments or questions. I apologize, parents. We are not able to address all of them right now. Feel free to continue to put comment and questions. I will try, and my team will try to go through. If there's something that really critical, we're gonna send a follow-up question to Judge Sakai and get his feedback on that. I do wanted to touch on. I know that you are running for. In your campaign right now, and there's some very critical items on your platform, talking about fighting inflation and all that. But in particular, I thought this one was really interesting. One of your platform is about the justice system, which is creating the rocket docket to speed up the justice system. Will this help the parents in my audience?
No, that rocket docket is to apply to the criminal jurisdiction. Getting those criminal cases that have been sitting, and obviously, unless we move our jury system, but again, not so much a rocket docket, but basically going back, getting these cases timely disposed of, and getting firm dates and holding the litigants and their attorneys accountable for the deadlines of case. That don't let these cases stay without deadlines. Yeah. Got to move them. You got to make decisions one way or another. And unfortunately, sometimes, the lawyers and litigants will say, no, we're not ready, not ready. But I'm telling you, the more you push it to trial and ask for a final disposition, generally, the better outcomes you're going to have.
Thank you. Thank you so much. Do you have any final last words for parents before we finish with the session?
Keep the faith. I understand our justice system is not perfect. I understand judges don't always make the right decisions, or the decisions that you would think should be evident. So, and I get that. And always remember that the best interest of the children sometimes means you got to let go, you got to quit controlling, and you got to do your very best, and arm yourself with knowledge, arm yourself with training, arm yourself so that you are prepared to go into the courtroom and do the best job you can. And hopefully, I wish you all the very best.
Thank you. Just Sakai, please do stay. I just wanted to just say thank you to parents. Thank you so much for being here today. Please help us by sharing this, please liking this, so that the algorithm will help pushing this to more people to be able to see this. Please join our mailing list. It's on VictimToHero.com on our website. Thank you so much. And like I said, please do let us know any question or comments that you have. Later this week, I think it's this week, we have an interview with a legislator in Pennsylvania. She was an alienated child. So she's going to come and talk to us about her experience and how that's impacting her work now as a policymaker. So I'm looking forward to see you guys there. I'm going to come on and I have some comments and in the next day or so that I wanted to particularly talk about some kind of misinformation out there about parental alienation. So thank you so much, parents. Really, really appreciate you guys and stay wonderful. Definitely be strong. Thank you so much. Let me just, and just Sakai, please do stay. Let me just kind of get off the stream for a second.